Thanks everybody for joining us today, and welcome to our webinar on appeals. Remziye and I are going to take you through some of the key issues around holding a proper appeal today. This session is the final session on our People Matter series on disciplinary and grievances. And we're looking now at the final stage that's required for a fair process, that of appeals. Just a couple. So this is, as I say, a webinar on appeals. We last looked at how to manage the disciplinary or grievance hearings themselves and looked at those 5 issues there. Some of those issues will flow through into the appeal around particularly the employee reps and union officials and evidential issues. But this is going to look at specifically the elements that crop up under the appeal process. There are 5 things that we're going to look at today when dealing with appeals. We'll be looking at, Remziye and I will be covering review or rehearing, individual roles, assessing the evidence, the outcome, and record keeping. As I'm sure you all know, appeals are the final and one of the key aspects of the ACAS Code of Practices requirements for a fair disciplinary and a fair grievance process. It will be a final review of any decision that was taken at the earlier stage. And if an employer fails to complete a fair appeal, then it can lead to a uplift in the compensation that can be claimed by a claimant. I'm going to hand you over to Remziye, who's going to deal with the first topic now.
Thank you very much, William, and good morning to you all. It's great to have you all with us this morning. So the first topic we're looking at is whether the appeal itself should be a review or a rehearing. Now, it's often a question that comes up both in the grievance context and in the disciplinary context. Now, from a grievance perspective, it's important, of course, to offer a right of appeal. The ACAS code requires that in terms of fairness, but it's also important because it demonstrates that an employer is taking the appeal seriously and taking the entire process seriously. Equally important from a disciplinary perspective, because the appeal is often a key ingredient in potentially defending an unfair dismissal claim, and it is important again in terms of the overall fairness. So what's the difference between a review and rehearing is a question we often get asked, and actually we have to look at a couple of elements before a decision is made as to whether a review or rehearing takes place. Firstly, it's very important to be familiar with an employer's own policies and procedures. Often the policy itself will dictate, either the grievance policy or the disciplinary policy, for instance, will dictate whether the employer will deal with an appeal by way of a review or a rehearing. And by review, we mean the appeal chair or the appeal panel, and we'll come on to talk about that shortly, making a decision as to the overall decision made and giving findings about whether the decision made was a sound one and whether it was based on sound findings. A rehearing, on the other hand, is potentially reopening an investigation or having to speak to witnesses, rehear evidence, reconsider evidence. So it's a sort of more protracted, longer process. If the policy isn't clear as to whether it's a review or rehearing that's required, it's also really important to look at the grounds of appeal, because those will often very much dictate which approach is most reasonable and proportionate for an employer. For instance, grounds of appeal that complain about any deficiencies in a process will be quite important to closely consider, because ultimately a rehearing may well be appropriate if there are procedural defects in the initial process, and it might be an opportunity for the employer to actually correct any of those defects at the appeal stage. There's also a note on the slide there about potentially rehearings being more appropriate if the decision in question may well affect an employee's career, and it's a sort of substantive matter that does require an employer to start looking back through the process and almost redoing the process entirely. Now, another question that often comes up is how to deal with new evidence. And the guidance is clear on this. Best practice guidance from ACAS also is clear that if there is new information, this does need to be considered, and the parties need to be asked about their comments on any new evidence that comes to light at appeal stage. There's an interesting case that was decided recently on appeal, a British Airways case. Whilst not in the same context around new evidence, it's demonstrated that the entire process must be looked at, and tribunals are interested in whether the whole process is fair from start to finish, and that often it entails the appeal stage, as we said earlier in the introductions. Now, in this British Airways case, it was interesting because there was a dismissal under British Airways capability procedures following long-term sickness absence. Now, their policy dictates that they set provisional dismissal dates periodically, and then they offered the employee in question, a cabin crew member, the right of appeal as at each trigger point, as at each potential dismissal date. But what then happened was the ultimate dismissal did take place, and a right of appeal wasn't offered right at the end. Now, this was taken all the way to appeal, and the tribunal reiterated essentially that they are interested in everything that takes place in terms of fairness from start to finish. The fact that the employee was offered a right of appeal periodically throughout the process was enough in the tribunal's eyes to demonstrate fairness, and the fact that the appeal wasn't offered right at the end didn't take away from the fact that the employer had been fair and reasonable otherwise. So that's just a very neat reminder that the tribunal is interested in everything that the employer does from start to finish, and often the appeal is a key ingredient. It is always very fact specific, but with that in mind, we'll move on to the individual roles played during the appeal process.
Thanks, Remziye. So this is the second issue as to who should actually hear the appeal and what is the participant's role. The code again is very clear. It should be someone who is impartial and someone who's not previously been involved in the case. On that point, it doesn't mean that they can't have had interactions with the people involved, maybe the witnesses or the person who's raised the grievance or is subject to disciplinary. What it does mean is that they shouldn't have been involved in any part of the investigation or in any part of the original decision to dismiss. There was a case which was quite instructive on this called Ward, where the manager hearing the appeal had been involved in a decision about suspension and had spoken to a couple of the witnesses, one of the victims, the alleged victims of the claimant's actions, to check on their well-being. That was held that they were still impartial. That didn't affect their ability to be impartial, and they weren't deemed to have been someone involved in the case. The second criteria for the appeal, the person hearing the appeal, is that ideally they should be more senior than the original decision maker. That's on the basis that the person making the decision would have the authority to overturn the original decision if that was necessary. In smaller organizations or where it's already involving senior people, then you can go sideways. For instance, you could even go outside the organization to appoint an independent person to hear it if that was required. But if that person is, you just have to make sure that that person is is seen to have the authority to make their own decision on the appeal before them. You might want to consider training if it's someone that hasn't held an appeal before. If the matter does go to tribunal, it's always almost always one of the first questions that's asked of people who have made decisions in disciplinary processes that have led to dismissal as to whether they knew what they were doing, essentially. So training can be in terms of experience on the job training or some help before and preparation for the hearing. You could appoint them to this recording of this webinar if you want some assistance for people to prep for hearing an appeal if they've not done it before. As Remziye mentioned, some organisations won't have an individual but panels to hear an appeal. that tends to be in the larger organisations. That obviously gives you much more flexibility as to who you can pick to be part of that panel. The key aspects of the appeal person's role is set out here, and I think it's boiled it down to 4 top tips for a appeal manager to be successful. There are a couple of questions that have been raised about the right of appeal and specific grounds for appeal, and picking up on Remziye's point about rehearings. You don't have to do a rehearing. A review, you can certainly say in your policy that the review will be the standard, but the appeal officer should have that authority and that ability to decide that actually there are problems within the original process that would be best ironed out by a rehearing, and that would be a decision that they should think about if they are very concerned, either at the outset or partway through, and they need to convert it. The appeal officer shouldn't be too pedantic about the grounds for appeal. This is not a court of law. This is not something we expect, or the judge will expect junior employees, for instance, to be very specific. So generally, you're going to have to approach appeals with an open mind and be seen to be impartial and unbiased. Certainly, practically, some of the issues that I see when dismissals or disciplinary issues have gone wrong is where the appeal person has been slightly overzealous in cross-examining and trying to always being seen to be trying to prove the point and prove the dismissal. Really, it would be best to approach it as listening and trying to understand what the appeal grounds are and assessing those on their own merits. Hopefully, the early decision will be sufficiently robust that there won't be any need to unpick it, but that should be the appeal officer's role. It would be helpful on that point, Ben, about not being too pedantic about appeals, and this question about, should there be a specific basis or grounds for the appeal? Well, the person can appeal just because they feel it's unfair without really specifying what that means. So that would make it incumbent on the person hearing the appeal to try and tease out what those appeal points are, why it is that the individual feels that the decision was unfair. I appreciate there can be people who will appeal just for the sake of appealing, just to make life difficult, as it were, but they should be treated in the same way anyway, because ultimately it will be you as the employer to justify any decisions that you've taken. That's the burden of proof will be on you. I've put there, ask clear and open questions, following up on the language point. It should be approached as being trying to get to the bottom of what the appeal is about and what the complaint about the original decision is. And just to repeat, that the appeal person should try not to cross-examine witnesses, obviously, unless it is a rehearing, in which case it would be treated in the same way as a disciplinary process and trying to understand the truth of it all. I thought it would be useful just to sum that up with a quote from the ACAS guide on disciplinary and grievance at work, where it does suggest that people shouldn't be afraid of overturning decisions. I think politically and internally that may be difficult, but from a legal perspective, the suggestion there is that actually it has to be independent, and people would appreciate the independent nature of appeals if there are seen to be decisions that are rectified, bad decisions rectified.
Thank you, William. Now is probably a good time for a very quick reminder on the role of HR2. I know that this has been covered earlier on in the series, and the same principles apply in the appeal context. So HR's role ultimately at the appeal stage is to provide support, guidance and advice on law, process and procedure. We need to be careful as HR not to be interfering with the ultimate decision or with the decision maker. And another neat reminder on the slide there is that HR advice that is provided is not privileged. So what does this mean? It means that if a case were to get to an employment tribunal and there is a duty of disclosure, any advice from HR would be potentially disclosable. So just some quick reminders there. I know this has been covered, but also relevant to the appeal process too.
So the fourth thing we wanted to look at was assessing the evidence, the role of the person hearing an appeal in looking at what has gone on before. And I've boiled it down really, I think, to six key tests or checks, if you like, as to what the person hearing the appeal should look into. Firstly, and obviously the issue is, does the original decision stand up to scrutiny? Is there sufficient grounds for the decisions that have been taken? And that really is the heart of a proper appeal process. In looking at whether that decision does stand up to scrutiny, one of the key aspects will be whether the allegations in a disciplinary process were clear. Did the individual that was subject to disciplinary sanction understand what they were being accused of, and is that what they were actually the decision in relation to misconduct was taken on those allegations, that there wasn't extraneous information that came into play. The third issue to look at and to check and to kick the tires on was the investigation sufficient? Has there been enough of a review of the evidence? Has the person undertaking the investigation obtained all the evidence? And as Remziye said, it may be that new evidence comes to light in the appeal stage. Don't make sure that is considered. Don't just dismiss that because it wasn't put forward, even if it was available. Make sure it is considered. It may change the decision. The fourth point then, if the decisions were sound and the evidence was sufficient and the investigation was sufficient, then you'll be looking at what the employee said in defence, and was mitigation considered, i.e. is the decision is it fair or is it too harsh? One of the key aspects of looking at whether a dismissal under disciplinary process is fair or not is whether alternatives to dismissal were considered. So that would be a key thing for the appeal person to check. If there are faults identified, then that's going to be a decision as to whether those faults actually affect the basis of the original decision and whether that decision was reasonable. The question I suggest clients ask, people hearing appeals ask, is what difference would it made if that piece of evidence had been considered differently, or if that had been available at the time, or where would there change? If it's going to be a fundamental change, then we may need to review that decision, either overturn it or rehear it. If it would make a decision, then we can carry on. And then the other difficult thing for appeal people to have to consider is where there are conflicts of evidence, where there are situations for the the he said she said situation, or the contradictory comments. The legal test, just for assurance on the balance of probabilities, i.e. is it more likely than not to have happened? And so really the appeal person should turn their mind to the three issues there. Is the evidence credible, or who is one more credible than the other? You can take into account demeanor. Is someone appear to be not telling the truth, appear to be deflecting, appear not to be being honest about the situation? Motivation might come into that as well. If there's quite often that people will allege that people are saying things just to attack them. And then finally, consistency. Is it something that they've consistently said, or has their position changed at all? All of those factors, and it might be very, very small elements of one of those, may tip the balance for believing one side rather than the other.
So moving on to the hearing and the outcome itself, we've set out some useful pointers on the slide here as to what we suggest an ideal process looks like and how to tackle the process from a best practice perspective. So the first point is to be well prepared beforehand. So be well aware as appeal chair or as the panel of the evidence in the case, the basis for any decisions that have been made either in the grievance or disciplinary context, and be familiar with the evidence that witnesses have provided. There's a reminder also on the slide about considering potential adjustments. Again, I know that reasonable adjustments has been covered in some previous sessions. Same principles apply again if there is an individual with disabilities who may need some adjustments to the process. It's something to think about at appeal stage 2. So for instance, offering regular breaks if that's needed, thinking about a remote appeal hearing rather than a hearing in person. Those types of considerations are also very key in the appeal stage 2. There's a reminder there about the option to adjourn. Now, we often find this quite useful and find that the fact the appeal chair or the panel are adjourning also demonstrates that they are taking the appeal seriously. They're not rushing in any decisions that they're making. And it may well be that there's some points to clarify or some potential questions that need asking at the adjournment stage. So again, this demonstrates the overall sort of overarching fairness to the individuals. That the sanction itself cannot increase at appeal stage, that's worth mentioning. You can confirm and uphold the decisions made, or indeed impose a potentially lower sanction, but it's worth bearing in mind that the sanction cannot increase. And reasonable timeframes is another neat reminder there. The ACAS code doesn't stipulate sort of strict timeframes, and it's very much about reasonableness, about what's fair, about what's proportionate for an employer. And what we find in practice is very much that keeping the individual up to date is quite critical, even if it does mean that the appeal chair or panel needs some further time to deliberate and make a decision. The key aspect of fairness is to keep that individual updated and let them know potential timeframes and when likely decisions are going to be made. There's also an interesting point about vanishing dismissals that we wanted to explain, and that's because there's been a recent case, an Iceland Foods case, where a shop assistant was dismissed, raised an appeal, and they wanted compensation and an apology, but actually as a result of the appeal their appeal was upheld, and what this meant in practice was that the dismissal effectively vanished, and that's the sort of legal consequence, if you like, and that it does follow that there's an automatic reinstatement to the job role if that happens, and the motive or the intention of the employee is indeed irrelevant. So in this case, in the Iceland Foods case, the employee wasn't so happy because actually her intention in bringing the appeal wasn't to get her job back. She wanted compensation and an apology. So it's just a neat reminder there, I suppose, for all parties involved, that is the ultimate consequence. Although it may well sound like a common sense consequence, you might find that an employee who has different intentions may be quite surprised with that.
Thanks, Remziye. And then the final topic we just wanted to speak about was record keeping, which is really just stating the obvious. It is a requirement in the code and guidance that proper minutes are kept of the meeting, and that those should be made available to the employee whose grievance or disciplinary has been heard, and it should be recorded who was involved and the timings and dates, etc. You don't have to allow meetings to be recorded, and certainly there is an issue if it's covertly recorded. But as a word of warning, employment tribunals will generally allow recordings even if they've been made covertly. You can certainly ask people not to record it, and you can ask people to leave their phones outside, etc. But unfortunately, the things have moved on now that the tribunal will want to understand a recording if it's made. It may be as many of our clients do, actually you record it yourself and make a transcript available at the end, or a copy of the recording, rather than having a note taker. There are pros and cons that some people are slightly will be off put by having it recorded, but equally a lot of people feel that these days we're all quite used to things being recorded and are quite happy for that to happen. It will be personal data, as you'll be well aware for most HR records. So you'll need to make sure that data in relation to those notes, minutes, etc., in relation to that particular process are kept securely and only kept for as long as is necessary. So we had some really interesting questions actually. We've seen those popping up. So we're just going to spend the last 3 minutes looking at some of those questions. One of them, having spoken about the importance of appeal, we've had quite a lot of questions about how can you avoid having an appeal, which is which is an important point. So there's lots of questions around, well, what happens if they don't actually give any grounds? They don't really say why they're appealing, and they don't provide any new evidence. That I think it would be very, very rare when you would just simply refuse to hold an appeal. It's not expected by employment judges if it gets to a tribunal that they are doing some kind of court of appeal process and identifying faults, etc. They have a right of appeal, and that is a simple right to appeal. They don't have to tell you why they're appealing, how frustrating that might be. You can set time limits, of course. So sometimes you may feel that it's outside the time limits. But again, there is a general right of appeal, so you should hold an appeal if that is what is requested. And as I mentioned in the earlier part of the webinar, you should try and tease out what those grounds are so that you can deal with them properly. There is it's not just simply for the employee to make all the running on that. You will be expected as the employer, particularly in larger employers, to hold an appeal and try and understand what grounds of appeal there are.
There's also a couple of questions around the theme of rehearings and reviews, and we've had a couple of questions about whether you can be specific in a policy about limiting the appeal to a review, and yes, you can do. You might find that there are still elements that need clarification. So as part of a review, the appeal chair or the panel may well still go back and sort of revisit some issues for clarity purposes, but that doesn't necessarily mean they need to go through a sort of full-blown rehearing. And a few other questions similarly about, if offering a rehearing, does that mean that there is then a further stage of appeal thereafter? And the answer is no, not necessarily, because once the appeal stage is over, essentially the individual has exhausted the internal processes. From our experience, I think it's William, I don't know if you've seen any different, but from my experience, certainly that's been the case. And even if it weren't specified that that's the case in a policy, I think that'd be fairly reasonable and proportionate. So it's not a sort of opening a can of worms into another process, if you like, even if a rehearing takes place.
I agree with that, Remziye. I mean, I don't think policies should mention the possibility of rehearing. That's just for you in your back pocket if the appeal person has real concerns about what may have happened previously. So it's absolutely your discretion, and unless there's some regulatory or other reason why you would need to do a complete rehearing, you shouldn't. The standard position would be a review. If a rehearing is another good question about, there's a lot of interest about this idea of rehearing, and they are very, very useful if there has been a real problem, but I would say they are pretty rare. If it's decided a rehearing is necessary, if the appeal manager thinks there is a problem, then they can still go ahead and do it. You don't need to then reconstitute a whole new panel. That is their decision then to review it. But what you probably will need to do, or most certainly will need to do then, is to postpone the hearing, schedule another one where you will then bring all the evidence back to the appeal, so that the person hearing the appeal can then make a decision based on the evidence, and that may include bringing witnesses back, for instance, but will be a full review of all of the evidence, so their decision then replaces that of the original disciplinary or grievance decision. I think we've run out of time now, so we're going to say thanks very much for attending. And to just point out for those of you that want to listen to our next webinars, we've got the next one is on the 19th of March on the significant changes to immigration, and we've got the employment law update on the 21st of March. So please do register to attend those.